Angela Davis. Moreover, it is a great privilege and honor to be here at this wonderful university, the fantastic Muwatin Institute, and this vitally important conference. I want to pay tribute and offer my warmest thanks to all of those who made this possible, including Professor Muda Kassis and Joyce Kashu, Muda, Professor Kassis, the director, and Joyce, the programs officer of this wonderful institute. We are all in your debt. In the face of horrors in Palestine, here in Palestine, Sudan, Ukraine, and elsewhere, many have looked to international law as a remedy. Indeed, cases have been brought to international courts, and states and various United Nations bodies have declared the law to be violated. Talk closer to the microphone. But despite these cases and these denunciations, the horrors continue. In consequence, some have proclaimed international law dead, or at least on life support. It has been killed by power politics. Some insist that power can be challenged through current global structures, and so international law can be revived. Yet others say that power is the exclusive determinant of international relations, so claiming it can be challenged by law is delusional. International law, then, is neither dead nor on life support. What current events tell us is that it never existed in the first place. What I would like to do today is explore these issues through what is currently happening to the Palestinian people here. Here in Palestine, all the fundamental rules of international law are being violated by Israel. First, from the Jordan River to the Mediterranean Sea, the violation of the right of self-determination of the Palestinian people, including, within it, the right of return, and also the violation of the prohibition of racial discrimination generally and apartheid in particular. Second, here in the Palestinian territory Israel captured in 1967 and has controlled ever since, the Gaza Strip and West Bank, including East Jerusalem, in addition to those violations I've already mentioned, an illegal use of force and aggression, violations of many other areas of international human rights law, in addition to the prohibitions of racial discrimination and apartheid, including the prohibition of torture, inhuman and degrading treatment, and violations of the core rules of international humanitarian law, crimes against humanity, and genocide. The current plan for a trusteeship over Gaza would violate international law in multiple respects. I will address two. In the first place, the right of self-determination of the Palestinian people as it applies to the OPT, including Gaza, is a right to be self-governing as a general matter. Self-rule rather than rule by an outside actor. Any outside actor. Substituting Israeli occupation with an occupation by another actor is a violation of self-determination, whether or not the other actor is less abusive than Israel, and whether or not the trusteeship is time-limited, is irrelevant. As the United Nations General Assembly said 65 years ago next week, and I quote, "Inadequacy of preparedness should never serve as a pretext for delaying independence." End of quote. In the second place, agreements brought about through an unlawful use of force, as this one would be, and contrary to peremptory norms of international law, as this one would be, the right of self-determination is a peremptory norm, are void. The Palestinian people have been here before, of course, with the Oslo Accords. As I had the privilege to argue for the League of Arab States before the ICJ and the ICC last year, the best approach in such situations is to say that such agreements may be in force insofar as they are compatible with the peremptory legal rights of the Palestinian people, but those provisions which are not are void. As the International Court of Justice affirmed last year in the context of the illegality of Israel's presence here in the OPT in particular, all states have important duties to suppress Israel's violations of fundamental rules of international law, a positive obligation to bring them to an end, and negative duties not to recognize them as valid and not to aid and assist them. Many states are failing to comply with these obligations, whereas they were willing to affirm them in their submissions at the ICJ last year and vote in favour of the General Assembly resolution that set them out. Willingness to implement in terms of their own behaviour has been a different matter. The Hague group of states adopted an important set of pledges to take concrete action, but these constitute only 7% of the world's states, and their pledge only covers a subset of the full range of obligations that all states have here. In the face of such a dire picture, international lawyers will usually make defensively 3 arguments. First, although high-profile situations like the situation here in Palestine are a focus of attention, actually, if we look across the board to all states and to all situations, including day-to-day ones, then, to quote the late US international lawyer Lou Henkin, most states comply with most of international law most of the time. Incidents of non-compliance should not then be taken to mean that the law does not exist. They're evidence that the law which exists is not being complied with. In the second place, they argue that certainly when it comes to the principal violators of international law here, Israel, the US, and other supportive states, these represent a minority of the world states, and the global majority is against these violations and in favor of upholding the law that's being violated. Look, they say, at all those states who participated in the ICJ advisory opinion last year, the highest number ever until the climate change advisory opinion later that year, the vast majority to support the contention that Israel was violating international law. Likewise, they invoke the large support given by states in the General Assembly, whether the speeches from heads of state or through a voting record. These rules of international law being violated by Israel and its supporters exist then because the majority of the world's states say so. In the third place, when it comes to the existence of double standards, for example, Western states contrasting approaches to illegality as between Russia's use of force in Ukraine in recent years and Israel's use of force here in the OPT since 1967, international lawyers insist that this can enable a form of imminent critique. States' own commitment to rules in one area can be invoked against them in another like context. The invocation of one or more of these three arguments is then a springboard for a push towards greater compliance. For the first argument, states who violate the law are reminded that they do comply with the law most of the time, and so need to remedy any deviations from their normal behavior, given the commitment to the law evident in the areas of compliance. For the second argument, it's pointed out to these states that most states in the world are in favor of the rules they are violating, and they should, therefore, bend to the global majority will and stop being global pariahs. For the third argument, the hypocrisy of states is called out on the basis that shaming them for double standards will lead to compliance. These efforts are animated by the belief that the current situation we have is better than nothing and a start from which can be built a more comprehensive, universal system. Pushing for compliance is, therefore, a productive use of limited time, resources, and effort. Where does this belief come from? To have a rational basis, it has to assume that the seeds of expansion exist in current developments, that progress is in fact possible within the current system of international law and institutions. But is it? We have to reckon with the alternative account of the international system, which would be offered by, for example, realist theories within the discipline of international relations, who see power as the ultimate determinant of global relations. Here, states' behavior is determined by political preferences mediated by their abilities based on their material capacities and power relative to other states. So, for the first argument, most states comply with most of international law most of the time. The realist would say, yes, powerful states comply with international law a lot of the time, but this is because it suits them. Then they depart from it when it doesn't suit them, and they can get away with it. Likewise, other states will comply with those suppression duties if they want to, and if they do want to, if they can withstand any pressure not to by the US and other states supportive of Israel, who may be able to exercise power over them. Current levels of compliance or not, then, tell us nothing about the likelihood of greater compliance conducted in circumstances where it would cut against preferences and or power pressures. Or rather, it tells us nothing positive about such likelihood, and indeed may tell us why it is unlikely. For the second argument, that violating states should bend to the will of the global majority, the realist would say it's easy for states, the states of the global majority, who are not themselves violating the rules of international law in this case, and are unlikely to, for example, the rules on the use of force, which by their nature are only going to be violated by a few militarily powerful states, it's easy for all of those other states to take robust positions on this subject. They would, wouldn't they? The fact that they do this tells us nothing about whether the powerful states who would have their own behavior constrained would be willing to commit to such constraints. For the third argument, double standards, the realists would remind us that hypocrisy is a core feature of human behavior and, therefore, has to be understood not as a bug, but a feature of global diplomacy. Calling states out for it, therefore, is not a politically effective strategy when it comes to motivating changes in behavior. In the light of these realist challenges, we have to ask whether we really should accept what international lawyers say, which is to insist, despite the realities staring us in the face, that we adopt a faux naive position, taking what states say, whether in submissions at the International Court of Justice or in statements and votes at the UN General Assembly, at face value. We use the term virtue signaling to refer to a situation where a person makes a public declaration affirming a particular normative position in circumstances that do not require any material alteration in their behavior and indeed can be seen as an alternative to taking concrete action. The term international law virtue signaling is, I would suggest, helpful in explaining the role that invocations of international law can play in diplomacy. In all of this, it's necessary to remind ourselves what this thing is that we call international law and how it is enforced. There is no global sovereign who makes and enforces international law. The law is made, somewhat paradoxically, by the very actors, states, to whom it applies, and enforcement is largely a matter of self-enforcement linked to the idea of reciprocity. It is in states' self-interest to comply with the law because they benefit from others doing the same. This logic presupposes the legal fiction that all states are equal. As states are, in fact, not equal, there is no reason why the most powerful states must comply with their obligations, as they can secure the benefits they would get from having other states comply with their obligations through other means, power, at least when it comes to states that are less powerful than themselves. The situation is different for peer states. So those states can have their cake and eat it when it comes to less powerful states. Others, the other states, have to do what international law requires, whereas they can comply with international law only when it suits them, or only, as I mentioned, if they're dealing with a peer state. The only other binding mechanism in international law is, of course, the UN Security Council, acting under Chapter 7 to impose obligations on states against their will. And that is set up only to operate provided that the three most powerful states in the world, and also two other states, don't object, so effectively excluding these powerful states from ever being subject to Security Council action against their will. This is critiqued as unjust, as undemocratic, unlike the General Assembly, where every one of the 193 UN member states has an equal vote. In consequence, it is said, the Council should be reformed and or bypassed, if necessary, through General Assembly action, hence the discussions currently taking place about the possible adoption of a Uniting for Peace resolution from the General Assembly that could somehow mandate a protective international presence in Gaza. But enshrining aristocratic privileges in the P5 was adopted because this was seen as the only way of ensuring that the most powerful states in the world at that time, in 1945, would be part of the system. If they had this power and their own actions and global spheres of influence were exempted from effective coverage. This was to avoid what happened with the League of Nations, which adopted a relatively more egalitarian system of governance, and as a result was faced with a situation where the US never joined and other powerful states left. And to harness the power of the powerful states to the system for enforcement in circumstances where they could agree. Necessarily then, the system cannot work and is not supposed to work when they cannot agree. One only needs to imagine the idea of a protective force being somehow created by the UN General Assembly in opposition to the USA, which would therefore have to fight Israel and the US into Gaza, to see how General Assembly enforcement action in opposition to one or more of those three powerful permanent members of the UN Security Council only works as an idea if one somehow discounts the material realities of power. The challenge here, then, is the challenge of unequal power in the material world. The international system of law and institutions reflects it and enables it to operate. But it would exist without the system. And so the system cannot be set up as if somehow it does not exist. Otherwise, it would be like the League of Nations. This is why the enforcement of international criminal law through universal jurisdiction nationally and internationally before the International Criminal Court has long precipitated such an exceptional response from powerful states, because this jurisdiction potentially operates universally and automatically vis-à-vis leaders of powerful and less powerful states alike. Powerful states can and do pressure other states to enable, through prosecutorial discretion, that national courts don't exercise universal jurisdiction as part of their more general projection of power over these states that is a part of an everyday feature of international relations. But the ICC challenges this because it is not part of the state system set up diplomatically to be amenable to pressure. Hence we see the extraordinary measures taken, for example, by the US against the ICC. The current measures are nothing new. Over 2 decades ago, when the ICC came into being, the US Congress passed the American Service Members Protection Act, informally referred to as the Hague Invasion Act, and the US State Department launched diplomatic efforts to get states who were parties to the Rome Statute to agree that they would never surrender US nationals to the court. Something that I and the late James Crawford, who of course drafted the Rome Statute, were commissioned by a human rights NGO in the US to write a legal opinion about, explaining why these agreements were unlawful. Plus ça change, plus c'est la même chose. Now, of course, we have the sanctions by the Trump administration, which are all explained in terms of the ICC in particular, against the ICC judges and prosecutor, against the United Nations Special Rapporteur on Human Rights here in the OPT, and against 3 Palestinian human rights NGOs here in the OPT, Al-Haq, Al-Mizan, and the PCHR. It's instructive to compare this extreme, unprecedented action to the responses to the General Assembly resolutions on Palestine and the ICJ advisory opinion last year and this year, which on the subject of Palestine are much more wide-ranging in what they address when it comes to illegality by Israel, compared to what the ICC has done and might do. With the ICJ advisory opinion last year, for example, Israel didn't even participate in the oral hearing, preferring instead to have its arguments made by proxies. The US, UK, Zambia, and Fiji duly obliged. The opinion and the subsequent General Assembly resolution were dismissed, of course, but no sanctions were taken against the ICJ or the UN. Likewise, with the genocide case brought by South Africa, although Israel has turned up to respond to the charges and various steps have been taken, again, the ICJ itself has not yet been sanctioned. This contrasting treatment of those 2 courts in The Hague is perhaps telling us about the interface between power and international law enforcement. Ultimately, the ICJ can be ignored, since the only concrete enforcement mechanism that exists internationally, the Security Council, will never be activated due to the US veto. But the ICC, which can lead to enforcement against individuals, or at least drastically restrict their travel options, must be taken more seriously. We have to ask whether it is realistic to expect these arrangements to be able to withstand such attacks, given that their raison d'être is, by design, at odds with the nature of the geopolitical system. What current events are, I think, telling us is that international lawyers have to be a lot more modest about the claims they make for international law. Commitments can be taken at face value when they map onto the power and politics matrix. But when they don't, we have to be honest about their limited value. International law is a powerful means of making political arguments in the international arena. It can be valuable in that sense, in a political sense, insofar as the substantive content of the legal rule is understood to have political legitimacy. So, for example, that rule I mentioned earlier, that agreements procured through the use of force are invalid, encapsulates the very important political idea that I have heard expressed in the context of the Oslo agreements by Diana Buttu and before her Edward Said, that when a person has a gun to their head, the idea that they are giving an agreement in any meaningful sense of that word is a lie. But the case for the global acceptance, implementation, and enforcement of moral and ethical imperatives like that one ultimately needs to be made in the realm of politics and power, and through direct action in the material world, not simply through statements, legal submissions, and indeed speeches. Thank you.